Thank you for joining this Part 2 webinar. I'd like to let you know in advance, there's about 10 to 11 slides. Each slides have a lot of information. The content is heavy, and I'm trying to figure out how best to approach this. I don't want it to be too heavily focused on the written English. I want it to be comfortable and easy for you to grasp. The PowerPoint slides are brief, but I will expand on them in ASL. While I'm doing this, I'm not able to see you when I'm sharing my screen. It will be hard for me to know if some of you have questions. Therefore, I apologize for that in advance. I will check the Q&A at the end of my presentation. I will be mindful of the time and leave enough time at the end for some questions. If I do not answer your questions today, I will answer them next week. If you're okay with that, today we will be focusing on the essentials of estate planning and these 5 topics. I will touch on these today. Validity, executor or agent, inventory, and the 4th is to set up a trust or not to set up a trust. Lastly, communication. It is my hope that I touch on all of these today. Now it is still early in the morning. Please forgive me. So this slide we're looking at validity. Any documents related to estate planning also applies to contracts. So think about legal documents, whether that be a will, a contract, or an MOU. These are essential things that you have to remember. And when you have the document, it is legal and binding. First and foremost is the legal age. We know that in this country the legal age is 18. Any person under the age of 18 cannot sign any legal documents and have that document hold up in court. It doesn't work. The view is that a child under the age of 18 does not have the required skills or the know-how of what a legal document is. So in regards to estate planning, the court will look at these items and see if the document was written by somebody over the age of 18. This applies to a witness as well. The person who is watching you sign the document also has to be over the age of 18. Mental capacity. When you're writing up your document, your mental capacity has to be clear. A situation may come up where an individual has dementia or Alzheimer's. The court will want to make sure that when you've written your document, that you know what you're doing, that you know what the document is for, what it's about, you know who you're designating as beneficiary. Mental capacity is very important. Often a legal challenge that will be brought to court is a person will say, this person who signed the document was not in the right state of mind, they didn't have the mental capacity. This document cannot be valid because they did not know what they were writing. I often work with individuals who will say that their parents already have dementia. They want to become power of attorney. They became power of attorney last week, and I will say that cannot happen. If a person or any individual has already been diagnosed with dementia or Alzheimer's, They do not have mental capacity. They do not have the mental capacity to fill out a document or sign it, and you cannot proceed with that process. It is a challenge because it's a fine line, and it's hard, especially with adult children who struggle to figure out how to care for their parents and want to make sure that everything is arranged, all the paperwork has been set up before they get worse. It's hard to know when the right time is. As I said last week, it's never too early, but it can be too late to arrange your estate planning. Third, intent. Bottom line is, I want to do this paperwork. I want to arrange my estate, get that all in order. I know what I'm doing. I know who I'm designating. I know what property I have. I know what amount I'm going to designate to each person. I have full mental clarity of what I want to do. Fourth, voluntary. That's self-decision. Another legal challenge that will be brought up in court is coercion or duress. We hear many stories of senior citizens being forced to rewrite their will, rewrite who they're designating to. Maybe the specific individual has no relation with the person writing the will, but they're being pressured to change their documents. One incident, I know of a person who was forced or under duress by the church to rewrite their will. Unfortunately, they never were able to reverse that, and when they passed away, everything went to the church. Do not do that. That is clear duress. That is pressure by the church. And tell the person, rewrite your will and give me everything. I warn you about that. There's nursing homes with staffing or caregivers, caretakers. A court will look at that suspiciously if the document has been rewritten or changed to designate any of these staff or caregivers as beneficiary. The court will be skeptical of that and wonder if there was coercion or if there was duress, and they will investigate that. The issue of being voluntary is very important here. Fifth, this is proper disposal of your property, meaning I don't intend to do anything that's criminal related with my property. It's very simple. I want to make sure that I'm giving my money to a legal organization, not funding anything that's related to hate crimes or terrorist activities. My property designation will be to people that will not turn that into any crime activities. It's very simple. It's not a complicated concept. Lastly, a signature. I mentioned last week briefly that all documents must be signed. The signature itself covers all of the previous topics I mentioned. It says who I am, my name. I know exactly what I'm doing. I know exactly what document I'm signing. This document is what the document is for. I can explain clearly that I have signed this document willingly. All 6 elements are important to set up for any validity to any legal document. Let me check and see if there's any questions. Okay, perfect. Moving on. The second topic I'd like to discuss is how to select a person to be responsible for my estate and make the decisions for me. There's two words here, executor and agent. Executor applies to a will and trust. This is a person who will take responsibility for managing your estate once you pass away. An agent is a person who coordinates with the POA, power of attorney, for decisions related to healthcare or your finances. Now, these 6 elements are strongly encouraged. It is not legally required, but it is something that all of us need to remember. Bottom line, you can pick whomever you want, but it is strongly encouraged for you to consider these 6 elements. Arrange who is responsible, who can handle many details, who can arrange and order things to the best of their ability. If you select someone who is disorganized, their schedule is impacted, they often make mistakes, compared to somebody who is organized and arranges everything in order. Both will be fine, but you want to make sure that you pick an individual who is capable of handling additional responsibilities. Managing an estate can be very complicated. It can be time-consuming. You want to be sure that that person is ready to handle additional details and manage your estate. Detail management requires a lot of additional paperwork, filings, court appearances, contacting different organizations or entities, and so forth. You want to make sure that the person that you designate or ask is going to be able to handle that. Second, alternates or backups. For my own estate plan, I have 5. I have a team of 2. I have a primary, and then I have 2 others, and then I have backups. It might seem like too much. Maybe you want 1 primary and 1 as backup. That's fine. There's people who do not have any alternates, and that's okay. The challenge is that when looking at number 6, once you pick, that's it. But who will replace your beneficiary? It's best to pick a backup, an alternate. 2 is great, 3 is nice, but I always encourage people to consider a minimum of 2 people, if not more. Third, we'll talk about geography. There is no geography requirement, none. You can select an individual who does not live in your local area, but the challenge is everything has to happen where you live. Your property is based on where you filed in the court in your area. If the person lives outside of your area, maybe out of state, they will have to frequently come to the area, appear in court, do inventory, and so forth. So geography is something to keep in mind. You want to make sure that that individual is able to do the work, whether they live locally or if they live far away. If they live far away, there's additional responsibility, so you want to consider who you're going to designate. Fourth is trustworthy. You will be sharing some of the most confidential personal information related to your life. Your social security number will be shared as necessary for identification purposes. You'll be sharing your financial information. You will share your most private information, and you want to make sure that the person you select will honor your information and keep everything confidential. Your estate information is not for everyone to see or to discuss or gossip about. You want to be able to trust the person. Make sure that they're trustworthy and trust that they will do good work. You want to select a person that you trust will listen to what your needs are and what you want. The goal of the estate plan is to document what your wishes are, what your expectations are for your property, for your health decisions, all of that. It's your desires, your wishes. You want to select an individual that will honor that. You have to trust that person. Fifth is communication. Death does funny things to people. Maybe while the person is still alive, a person is caring and can interact and everything's fine, but once somebody passes away, then it triggers arguments and bickering and people saying, that's mine, no, that's mine. It happens all the time. It's not a bad thing. That's just an impact that happens after somebody passes away, unfortunately. Your executor has to be the person who can handle any potential upset. If something comes up with family members and an argument happens, the executor can manage the situation, communicate, discuss amongst each other. This has to be a person who can handle the drama. This is very important. Communication also applies to finishing paperwork and filings in court, dealing with debtors. A person who can manage a variety of communication needs. We all know that the world is a hearing world. So being able to deal with a variety of hearing businesses, it can be triggering for some people. Oftentimes it is triggering for me as a deaf person. You want to pick somebody who is able to interact and deal with people and maintain calm and be able to stay calm when things arise. Sixth has to be when the person who's asked to be a beneficiary has to be willing and available. You cannot require your selected person to do it. You cannot force them. Legally, you cannot. The person has the right to say, no, thank you, I don't feel comfortable, or say, no, I can't, I just don't have the time. That's why we encourage you to consider different people. If your first option declines, then you have backup with a second, third, fourth, or fifth. These 6 items are what I encourage you to do when you're thinking about selecting an executor. If you have children under the age of 18, this becomes more essential because you want to pick somebody who is going to be taking legal responsibility of your children. You want to select somebody who will become a parent for your children, someone you trust to raise your children through adolescence into adulthood, considering what your desires are. So you want to consider who you're going to pick as an executor or an agent. So these are 4 bullet points who you cannot select as an executor. Children under 18. This applies to legal age. Children under the age of 18 do not have any legal authority under the court's view. Felons, those who have a documented felony on record, most states will say no. The assumption is that a felon cannot be trusted. Felons have lost a lot of rights. They've lost the right to vote, for example. So the court will not accept a felon as an executor. The last two bullet points focus on state laws. Information that I'm giving you is related to California state law. I don't have information about all of the 50 states. So please check your state laws pertaining to executors. Some states require an executor to also be the beneficiary, which is interesting. In the state of California, that does not apply at all. Some states require the executor to file a bond to protect the estate. If in the event the executor does something in error or if there's theft, the bond will cover the damages. So you want to check your state laws, local state laws, please. Just checking the time, and it looks like we're doing good. The third focus is on inventory. This is basic housekeeping. There's a lot of organizing to do. Your estate planning documents. You have to decide which document you want to write up. It could be as simple as your will. That's fine. You want to make sure you have multiple documents and have everything arranged and in order in one place. Oftentimes when I'm writing an estate plan document, everything is included in one brown envelope and kept in one location. If you're adding something new or changing something, you shred it, put in the new document, put it back in the brown envelope in the same place. It's always good to have a list in your inventory, the will, a POA for financial decisions, POA for healthcare decisions, final arrangements. You want to list and inventory this on the brown envelope. It is always beneficial for me and also for the person who is going to be taking over the responsibility. Accounting related to finances. That includes your bank accounts, your checking account, all of them. You want to include your account number, which branch you go to. If you have online accounts with the bank, you want to include your login and password information. Your retirement accounts, a 401k, an IRA, retirement benefits. Again, include the account number and which company it is under. Balance statements will include your statements. You want to include that in your documents. If you have investments, portfolio with a company, you want to include all of that information, the account number, the company that it's listed under, any annuities that you receive from your investments. Include all of that. Included with your finances is your insurance policy, whether that be life insurance, for example. Make sure you have copies included with all of your financial documents and that paperwork. Have it ready. Social media. All of us have multiple social media accounts. I think I have Twitter, Facebook, Instagram accounts. There's multiple others. You want to create a list of your social media accounts and list that because people will use these accounts to also notify the world that you have passed away. And they can notify everybody at once. Any personal property, that can be very time consuming. I work with one group who's very involved with art collecting, and there's many, many years of collections and just array of artists and large and small sculptures, photography. And after discussing with them, they were going to photograph each art piece that they own. Seriously, every art piece that they own, they photographed, plus a description of what the art piece is. Taking a photograph along with the description of what it looks like, then moving on to the next piece, doing the same thing, photograph and a description. This is an awesome way to document and inventory your art because you can't miss it. It's clear. You have an image and a description of the art piece. When you're writing the will and distributing to different beneficiaries, you will have this document and it's already labeled A and B and so forth. And all of your furniture pieces. Many people collect antiques or vintage items that can be very valuable. That's also worth photographing in inventory. If you have jewelry, some people have just a list of jewelry and they want to give them to specific people. If I collect like ruby necklaces or red stone, I will list different rings and necklaces. If I put down one ruby ring, that's not clear enough. That's not clear information about that specific ring. So taking a photograph of it is really beneficial for the purposes of recognizing which ruby ring I want to give to Mary. People struggle with inventory of personal property because they have to look at what they have. It can become overwhelming. There's so much stuff, and you're thinking, where do I begin? I often encourage people to start with one specific category. Maybe starting with oil paintings, or starting with your photography. Take a break and then focus on the next category. Debts. Many of us have various debts, credit cards, house, loans, car loans. We have this. This also has to be documented because when you pass away, your debt does not go with you. The companies have the right to collect payment for the debt owed. That's part of the formal notification and probate, letting debtors know, and when there's a time and a place for them to require the payment. Any information you have in regards to your debt must be listed. Any memberships. Some of us have multiple memberships relating to professional organizations, AARP, NAD, Gallaudet alumni or college alumni, and so forth. It's also worth documenting that. It's of less importance, but it's a good idea to document it. You will, because they will have to be notified and memberships canceled. Last on this list is essential people. It's critical to know who will get what. That will be included in the will, but sometimes it's nice to have a separate document for a quick reference and know that this person will get this item and move the process along. It's beneficial to have when it's time to distribute your property. Let me take a look here. Okay, I do see a question. Unfortunately, I'm not able to see the whole list, so I will check that after my presentation ends. Now we will discuss a trust, or maybe not to do a trust. People will ask, should I do it? I hear that it's the best way to save money and time and so forth. What a trust is all of your property lumped into one trust, and it is held for when it comes time to distribute to the beneficiary. It works in tandem with your will. Your will is included in the trust. The trust does not deal with property disbursement. The will does that. Your will outlines all of your property, finances and personal property, estate property, all of that is included in the trust. Your property must be included to be protected. Often people will do a trust for 3 reasons: to reduce financial liability, to protect personal property, and avoid probate court. That's the general reasons why to set up a trust. It's not always necessary. I myself, I do not have a trust for my property because the total value of my estate does not make it worth setting up a trust. The value of your estate is really a great guideline to decide if you should set up a trust or not set up a trust. The trust is beneficial in maintaining privacy. In probate court, that's public record. Anything that's in probate court, it becomes public record. When you pass away and the will is filed in probate court, the will becomes public information. People can read that and reference it when it comes time to distribute your property. A trust does not have to be filed in probate court at all, which means everything is kept private, which is a good benefit. And you can have more control over your estate. You can manage your estate. At the same time, when you set up a trust, it can be very expensive. When I mentioned the value of my estate and looking and analyzing that, it's really not beneficial for me to set up a trust. So you really want to look at the overall estate to determine if it's really financially reasonable to set up a trust. It's also a time-consuming process. I strongly recommend that you hire a lawyer to draft your trust. And you can do the will as well, but it can become complicated. Even if you set up a trust, you need the will. It works together. You cannot have a trust without the will. Going back to time consumption and that process, what came to mind is that all of your property together must be referenced in your will. And the will is referenced in the trust. That process means all of the property that is identified and listed in your will is now protected in the trust. It's really a process. You have to make sure and think about every single thing, every detail that you want included in the trust for protection under the trust rules. If I have not notified anybody of my wishes, everybody will think about what I want and debate or argue about that. If I already inform everybody, they know what I want. Discussing about death is very difficult. A lot of people do not like to talk about death. They don't like to be faced with that mortality. It can be sensitive, it can be triggering. But it's so essential to at least start that conversation. I'm very clear with my health decisions and what I want. I'm clear with my friends and my family and notifying them of what my healthcare decisions are. Because I could be with somebody when something happens and they'll be ready to say, no, she does not want this, she wants this. So this is very critical. The absence of communication can lead to many opportunities to come up with arguments and fights, and that will happen. As I mentioned before, death does funny things to people. It can change people. I've seen many families who are close with each other, and when parents pass away, they all of a sudden hate each other. They want this, they want that. They start fighting, and it's really sad. So you don't want that to happen. Take the time to sit down and have that communication and notify to minimize all the fighting and arguments. Well, I was able to touch on everything. I'm relieved about that, and I'm making good time. It's 10:44 now. When arranging your estate planning, it can be a traumatic experience. It can be triggering. It will be overwhelming. You will experience exhaustion, and that's okay. The planning process is not a race. It's not a rush to complete. I do not recommend that you rush through this process. Take your time. Go through everything step by step. And take breaks. Take a breather. Ask for support, because this process is emotional. When you're faced with the potential of death, we all will pass away. And we don't like to talk about it, but we can manage what happens after we pass away with good planning. So I encourage you, no matter what age you are, whether you're young or you're old, document, please. Next week, I will discuss planning and how to start this process. Now I'm going to stop sharing my screen and I'm going to look at the questions. I see 4 questions. The first question is, can I have more than one executor? Answer is yes. I have 2 teams that work together. Grief does impact how you can think and the ability to think clearly. Second question, can children be selected as executors? Yes, but again, remember how an individual responds to grief will affect mental clarity or capacity. You want to select somebody who will be able to handle the process after you pass away. Children are often selected as executors, and oftentimes it works out great. Just remember that they're also supportive and that communication is there when arranging everything. Another question, will everything be shared equally? Yes, an executive can be a part of the team. Again, I've selected 2 of my close friends who have equal responsibility and they support each other. Hopefully that works. Other question, when writing up a will, should I make a copy and give it to the executor or keep that in my house and just let them know where to find it? Thank you for that question. Yes, your original document you keep. You always keep that in a safe place in your home, maybe in a fireproof box or safe. Or you could have it in a safe deposit box. That is possible. Your executor should always have a copy. Always. But the original document you keep. And again, it goes back to communication. You let the executor know where to find your will and what to do with it. You keep it in a safe place. Okay, we're doing good. Someone has asked, why would you put the trust's name on my deed and how can I remove the name? I'm not using my will anymore. Okay, so for clarification, your will is something you always should keep. It's important. If you have a trust and you want to eliminate your will, you can't do that. They must be together. The trust and will work together. They have to be together. And you want to make sure that your will is still valid. It's still good. You can update it, but it's important to look it over and make sure that everything is good, or if you need to change something. Check your will. Going to the trust name, that's easy to do. You can change the name. You just have to do an amendment. Where you've indicated the old name and as of now, going forward, changing it to the new name. Everything related to the trusts and the name also has to be replaced and changed. Oftentimes people will set up a bank account and use a trust name. If you change the name in the trust, you also have to change the name of the trust under your bank account. So make sure that your will is still valid. You still need the will to go with the trust. I do hope that answers your question. Okay, a situation has come up where somebody wrote a living trust with 4 beneficiaries, but the first beneficiary listed will receive everything. Okay. So there's 4 beneficiaries. One person will be receiving everything. If the first beneficiary passes away, it goes to the second, and so forth. The question is, what happens if the first designated beneficiary passes away, the second one moves into that position, but there's no trust set up, no will, any legal issues that come up? What should that beneficiary do prior to passing away? They should do their estate planning documents as well. It's simple. If your first designated beneficiary inherits anything and doesn't have any will, they have children, the court will follow the procedures for identifying who is legally allowed to inherit. California state law recognizes the bloodlines in terms of handing down the estate if there's no will. If a person has a spouse, or if there's no spouse, there's children, they distribute it equally. If it's one child, then it's 100%. If there's 2 children, it's 50-50. And that's how the process works. If there's no spouse, no children, and if parents are still alive, it will then be dispersed to the parents. If there's no parents, we'll go to the siblings. Now, in regards to the children, if the adult children have passed away but their children are still alive, it will then go to the grandchildren, for example. The court will follow that line of succession if there is no will. Every state has their own way of disbursements in the absence of a will. Check with your local state laws in regards to that. I hope that answers your question. Another question, do I let the executor know where to find my estate planning and my will before I pass away? Yes, please do. If you have everything arranged, awesome. Make copies and give it to your executor. Have them put it away and not read it. My original document I will keep, and I will notify the executor where to find the original document. If you move or the location has moved, you need to let the executor know. It's very important to have that communication, especially for after you pass away. Is a minimum of 2 executors good enough in order to distribute? To answer that question, an executor is different than a beneficiary. Those are 2 different things. Executors often do not benefit from the will. It is possible, and that's fine. It's not illegal. But if the 2 executors are given everything, that's fine. But you want to remember to separate the executor and the beneficiary. They're 2 different things. If you give everything to one person, that's fine. That's perfectly fine, and it is legal for you to do. I have another question here. When should I go ahead and start the estate planning? I keep thinking I'm young. I don't foresee anything coming up. You know, my thoughts are, it does not matter what age you are. Even if you have a small estate, it's still worth documenting. You may have some valuable art that you want to give to your best friend. One time I had put all of my shoes, that's one thing that I love. I would designate it to somebody who, is the same size as myself, and I indicate their name. Age does not matter because we can pass away at any time. I think that once we have things that are precious to us and we look at these things, we think about who we want to pass them on to. It doesn't matter what age you are when considering this. If you have something that you want to pass down and it's valuable to you, it's sentimental, it's a good time to start documenting and arranging your estate plan. Another question. Can they be beneficiaries? I'm not sure. Let me go back to the old question. Okay, I'm hoping I'm going to answer this correctly because the previous question asked, can my children be executors? So a follow-up, can they be executors and beneficiaries? Yes, they can be. A question here, if I move, do I have to check the new state laws even though I've already set up a will and estate planning in the state I did live in? Where it's set up in your state. Suppose you set it up in California and then you moved to Florida. Your will transfer with you. But because you've changed your residence, the original will that was written in California will adhere to Florida state laws. The only exception is if you own property in California. That will follow California state law, even though you reside in Florida. Okay, it's 2 minutes before 11. I'm going to try to wrap things up. Do I give the will information to my beneficiaries before I pass away, or just give it to the executor? You just need to give it to the executor. You don't need to communicate anything to your beneficiaries. I do not recommend that. I encourage you to communicate with the executor. That's most important because that's the person who's going to take responsibility for your estate. Another question here. My will was written in 2005. I've sold my house. Should I rewrite my will? The answer is it depends what you've written in your 2005 will. Anything that's in there that you want to change. If you have sold your house, does that mean you have to change the entire will? No. You can just change the section with an amendment. You're not required to change the entire will. That's one nice thing. You can write an amendment and attach that to the part in the will that you want to change. It could be as simple as the house was sold in 2007 and the will not reference that house anymore. Next question, changing a trust name through court, does that need to be done? No, it does not have to be done through court, but if you have a trust name in different areas like a bank account, life insurance policy, in different accounts, you will need to change the trust name in each of those accounts. It does not have to be done through court, no. Okay, I've gone that. Let me check mark that. Okay. For clarification to a question of more than one executor, if everything is given to the first beneficiary, can it go to a third party? Is it good to have two executors? Well, let me reread that. Okay. I always encourage people to have a minimum of two. It can be one person who's managing everything and one backup, an alternate. It helps to have somebody ready to go as a backup if my first option is not able to or not willing to. Maybe they've passed away, that you have a backup person. It's nice to have two people working together and supporting each other. If one beneficiary or executor doesn't know what to do, it's best to have two so they can bounce ideas off of each other. I can discuss more on this next week. I see that it's past 11. I'll answer one more question. Is an amendment for the purposes of changing things? Yes, the amendment is the purpose of changing what's in the original document, adding or deleting something. I will discuss more about trust next week. Yes. So thank you for your time this morning and bearing with me through this webinar. Thank you so much. Al, all to you. Thank you, Susan, so much, and I appreciate your time. Thank you so much. This concludes today's webinar, and I hope that you sign up for next week. Have a great weekend, and thank you.